A warm welcome, my friends. Very good morning. Let's start the journey of understanding and becoming a medical legal consultant. All the participants who want to talk will definitely going to interact with each other, but give me a little time so that I can finish up with the topic. Then we'll have a question answer and we can talk. Yes, Abhay, we will definitely come back to you and we'll have a chat with you. At this stage, just a moment, give me a moment so that I can complete. Today's very important topic for all medical legal consultants who are on the path of becoming medical legal consultant. Yesterday only someone had asked me, sir, how you are going to control across the country and all. So major case came to me and I was available for both the people, but little time management was separated because one place had no time. And this definitely question came. I very proudly said, not to worry, sooner we are going to have a group of people who are going to cater a major chunk of medical legal issues, and they are in the journey of becoming a medical legal consultant. And you are satisfied? Yes, because the cases started coming from every part of the country and every state, every district. It's not possible for 1 or 2 or 10 people to reach. So your importance are going to be much because every day things are coming in different modalities, in different mode. We don't know what type of cases are going to come and how it will be handled. Let me share yesterday's case of a hospital where a general practitioner has treated a patient of a diabetic foot with a natural uncontrolled diabetic patient. Referred it to surgeon advised him to continue. A small amputation was advised. Went to some quack who started with meropenem and all sort of a broader spectrum antibiotic, promised him that he will avoid amputation. Got deteriorated. First culture was done by the quack, which shows Pseudomonas meropenem resistant bacteria. Patient in critical condition got admitted to this tertiary care center, which doctor came to us. Tertiary care center have done all possible things to save the life of that particular patient, but 3 days, patient remained there and patient expired. This was the case. The mediator in all these cases were RTI activist and the anti-social person who wanted to extort a good amount of money from all the people, knowing that quacks were not having a qualification. He targeted the quacks. With police officers complained, he has targeted the critical care center doctor also. And utter surprise to hear that police officer has said, these doctor that we are going to put 302 on all the people. Murder. My friend, IPC section 302 does not apply to such a cases because it requires intention word. Even if at all quack does not have a qualification, his intention was not there to kill a patient. So naturally section 302 is no way is going to apply. What maximum can happen is 304, that is causing a death without intention, with the knowledge. Was having a knowledge that I don't have any qualification, still treating a patient in patient life can be a part and parcel. But nothing would have happened to my doctor who was really worried, terrorized, and these all things was only for the purpose of extorting the money by antisocial people till the time they came. So if such a people comes to you, and if it is part your knowledge that how 302 is not going to apply, is how you can remove the stress of these people by explaining the law that worst come worst, if at all, even if at all, any section for negligent need to be applied, it is going to be 304A, where immediate arrest is not there, going to take a long time. Your medical record, it plays a vital. When you have seen the medical record and there is nothing in medical record, you can assure them you not have to worry because whatever you have done is done in purview of treating a patient in a critical condition. And in critical condition, you already treated a patient. There's no question that people should be worried about all these things and they can be worried. This can only be possible when we share knowledge. Let me share many of the cases which is now cropping up in counsel. Today, I'm going to deal with all the laws related to medical counsel. As we all know that three liabilities are very, very powerfully been applied to all my doctors. It could be a criminal liability where the punishment in the form of a jail. It could be a civil liability where punishment is in the form of compensation, huge compensation in consumer court, or it could be in civil court. And third important liability, which really terrorizes a doctor a lot, is a medical counsel liability. And in medical counsel nowadays, cases are dropping like a mushroom because of the method of filing a complaint got changed. One tweet to Twitter, one later to Home Ministry, Health Ministry, or various body, one later to NMC or MMC or any medical council is enough to initiate the inquiry against law. But if it is justifiable, genuine inquiry, nothing happens. But nowadays, I've seen people are believing on internet information, going to internet, trying to find out some loopholes in the treatment of a doctor and filing a complaint. So let me share yesterday's complaint, which I have answered. It was a case of oncosurgeon who got a patient, elderly, 70 years old, diabetic, uncontrolled diabetic with advanced breast cancer, who treated a patient in the past with the chemotherapy because the first important aspect to the doctor was to ascertain what treatment needed after clinical and pathological examination. Surgery naturally always been kept at last, looking to the fitness and other things and all and requirement of the same. Rightly done by the doctor, he started patient on chemotherapy. Patient was recovering naturally because of the condition of the patient in COVID scenario. This was happened and notice received it day for yesterday. Patient may have died. The son of that lady has filed a complaint in all sort of a department. Around 12, 13 places he has sent CC while sending a letter to this doctor, including NMC, MMC, and every place, where he mentioned in his letter that you are not qualified to give chemotherapy and you have crossed over your field. The question definitely raised by this guy that you not being a medical oncologist, this is not your field and you cross over the field and given chemotherapy and caused the loss to me, where my mother died. I was utter surprised to see that later. Naturally, my doctor was most terrorized guy because he was not understanding that what he need to write because he was oncosurgeon. Probably he also got convinced with the letter that I don't have any power of giving oncology treatment. But that is wrong. I said not to worry. Oncosurgeon and oncologist both are of the similar field. And we answered. But why I'm sharing all this, that such a matter also goes to medical council. See, medical council where all frivolous things can, people can go for anything and everything. Let me share yesterday's, I was up to, it was a very, uh, doctor was much worried. He was HOD to government hospital in Mumbai and he wanted me to accompany. Normally, I don't go to MMC or any medical council because this is the place where doctor need to speak. But just because of his worry, I attended the court with him. This was a case of 2017 where patient came with abdominal discomfort with a clear indication of gastritis. Doctor has done all investigation, proper investigation, including endoscopy. And on the basis of pathological and other report, given a treatment of PPI to the patient. 2018 January, last patient came to this doctor. Thereafter, never turned up. And then he sent a complaint to MMC saying that the treatment given by gastroenterologist has caused me sexual dysfunction, erectile dysfunction, which spoiled my life. Simple complaint of sexual dysfunction was done to MMC on without no basis, no investigation, no evidence, nothing, just a letter that treatment given by XYZ doctors caused by sexual dysfunction or ED and been taken by MMC, inquiry initiated, 2018 and today 2022, almost 4 years when this doctor got a letter. In between, he replied in 2018 when complaint was reached to us, and we thought probably it would have settled, but 2022. I was utter shocked when I attended this court. Lots of inquiry done for the purpose of a treatment. When I intervened and spoke to the authority that complaint is of ED, not of any medical negligence or any other unethical practice. And secondly, patient has never ever came back for the follow-up. It is difficult to understand that the complaint lodged by the complainant has got some value or not. And secondly, majority of side effects are irreversible. Sorry, reversible. When it is reversible, the moment patient would have stopped the medicine, even if it all side effect been shown, patient would have got normalization. So it is difficult to ascertain that. And even doctor when inquired about that, do you inform every patient about the side effect of the drug? It was really a tricky question because it's not possible for every single doctor to give complete detail about side effect of every drug, knowing that there is a constraint of time, there is a constraint of lot of things. Doctor said, I majorly do the same in a major patient where major side effects are shown, but I do write on a paper or inform if at all any adverse reaction found, please do come immediately or follow up within a stipulated period. I know the result is going to come in his favor, but why I'm sharing all this? Simply because in medical counsel, the action against the doctor can be initiated by any frivolous complaint and also not directly complain to MMC, but or any medical counsel rather, but just tweeting to various authorities can lead to complaint. But in my experience, majority, rather 90%, I can say more than 90% goes in favor of a doctor because such a complaints are a frivolous case.